Good morning and welcome to the Supreme Court of the United Kingdom. Today the court is handing down 3 judgments. I am Lord Briggs and I will summarise the first and second of those judgments. I will then ask Lord Sales to summarise the third. The first judgment is in the appeal Hurstwood Properties Limited and others against Rossendale Borough Council and another. This appeal is about a business rates avoidance scheme. Business rates are, in general, payable by the occupiers of business property. But since 1966, the liability to pay a business rate has been imposed on the owners of unoccupied business property, subject to certain exceptions. The owner is defined by the legislation as the person entitled to possession of the property. A main purpose of imposing this empty rate is to encourage owners of empty business property to bring it back into occupational use for the general public good. One of the exceptions to liability for the empty rate is where the owner of the property is a company in liquidation. So an avoidance scheme was devised, one version of which seeks to take advantage of this exception. It works in the following way. The promoter of the scheme sets up a limited company. I will call it a special purpose vehicle, or SPV for short. It has no assets, no business or means or intention of doing business. The original owner of the empty property grants a lease of it to the SPV on terms under which it can be terminated if the original owner wants to use the property again. The lease is designed to grant what a property lawyer would call a legal entitlement to possession of the property to the SPV, although there was never any intention that the SPV would ever make or be able to make any use of that entitlement, whether by occupying the property itself or by letting it to someone who would. Nonetheless, the aim is that the SPV then becomes the owner of the property within the meaning of the rating legislation. The SPV is then immediately put into voluntary liquidation, so that it becomes exempt from the empty rate. Then the liquidation process is deliberately dragged out for as long as possible, so as to immunize both the SPV and the original owner from liability to pay the empty rate. The financial advantage of that rates exemption is then divided between the original owner and the promoter of the scheme in pre-agreed shares. Another version of the scheme provided for the SPV to be dissolved as soon as possible after the grant of the lease, rather than put into liquidation, so that any liability for the empty rate would pass from the SPV to the Crown when, on dissolution of the SPV, the lease passed to the Crown as what is called bona vacantia, that is, unowned property, until the Crown found out about it and disclaimed the lease. Until then, the original owner would, it was hoped, not be the owner of the property within the meaning of the rating legislation. If at the end of the liquidation or dissolution process, the original owner still had no use for the property, the scheme could simply be repeated by another lease to a newly created SPV, which could then be liquidated or dissolved in the same way as before. 2 of the local authorities affected by these avoidance schemes challenged their effectiveness by suing the original owners for the rates and claiming first that the leases to the SPVs were shams, or that they were otherwise ineffective to make the SPVs the owners of the properties as defined, and secondly, that the separate legal identity of the SPVs should be ignored. This is called lifting the corporate veil. In the 2 test cases, the original owners sought to strike out the claims for empty rates on the basis that neither way in which the local authorities put their case could succeed at trial. The original owners were partially successful before the judge and wholly successful in the Court of Appeal. That court held that the leases were not shams, that they did confer an entitlement of possession on the SPVs so as to make them the owners of the empty properties, and that there was no basis for lifting the corporate veil. The sham argument was not pursued on the local authorities' appeal to this court, but we have decided unanimously that the local authorities' case is not bound to fail, so that they should be allowed to take it forward to trial. Lord Leggett and I give a joint judgment, with which Lord Reid, Lord Hodge and Lord Kitchen agree. Our reasons are in summary as follows. The starting point is, with tax legislation as with any other statutory material, to apply a properly purposive approach to its interpretation. In identifying the owner of empty business property for the purpose of liability for empty rates as the person entitled to possession, Parliament's purpose was to identify the person who, or which, might be supposed to have control over the occupation of the property, i.e. a real and practical ability to bring it back into occupational use, either by using it themselves or by letting it to someone who would. This is because the main purpose of the empty rate was to act as an incentive to bring empty business property back into occupational use. This purpose is not achieved at all if a bare legal right to possession is conferred upon a person which, under a pre-arranged scheme, is never going to have that control over the property at all. What is needed is for the person to have a real and practical entitlement to possession. In the present cases, on the facts which must be assumed to be true in deciding whether there is a case fit for trial, the SPVs were, as an inherent part of the schemes which included the leases, never to have any ability to make any use of their right to possession. They were to have no assets, no business of any kind, no staff of any kind, or any kind of active existence. They were just to be put into liquidation or dissolved as soon as possible. The schemes were deliberately constructed to leave the whole of the ability to decide whether, and if so when, the properties should be brought back into occupational use with the original owners, for which purpose the leases would just be terminated. Nor was it intended that the empty rate would ever actually be paid by the SPVs. They lacked any assets with which to do so. The whole purpose of the schemes was to avoid payment of the empty rate rather than to transfer the responsibility for its payment. Apart from rates avoidance, the schemes had no separate business purpose of any kind. Finally, both versions of the scheme necessarily involve the deliberate abuse of a statutory legal process, namely the insolvency legislation and the provisions for dissolution of defunct companies. A purposive interpretation of the definition of owner for the purpose of liability for empty rates could not therefore be applied to the SPVs under the scheme. As a result, notwithstanding the grant of the leases, and although they were not shams, there is a tribal issue that the original owners remained liable for the empty rates. We nonetheless agree with the Court of Appeal that if the SPVs had been the owners of the properties for rating purposes, the local authorities would have been unable to invoke the doctrine of lifting the corporate veil. If there is still such a doctrine at all, it would require it to be shown that the original owners had sought to evade an original liability of their own by interposing the SPVs. But assuming, contrary to our decision, that the SPVs were the owners for empty rates purposes, then they had the original liability, because liability for rates arises day by day, and the liabilities which the local authorities are seeking to enforce arose only after the grant of the relevant leases to the SPVs. Nonetheless, the outcome is that the appeal is allowed. The local authorities' claims against the original owners must be allowed to go to trial to establish whether, if it be in dispute, the assumed facts are true.